Morning, Ms. Hawkins. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On March 6, 2025, at approximately 10:29 p.m., the officer observed a vehicle driving with expired registration as of March 2021. A traffic stop was initiated. However, the vehicle continued to travel down the feeder road until it turned and pulled onto the wrong side of a two-way road and parked facing northbound in the southbound side of the roadway. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed the defendant to have bloodshot eyes, droopy.
All right, quick pause here. This is important context. Harris County's general order bond system is basically an automatic release for most misdemeanors. No judge, no cash, no hearing. And while that sounds lenient, it's actually the product of a federal lawsuit saying the old bail system punished poor people just for being poor. So from the jump, this case sits right at the intersection of public safety versus civil rights. Keep that tension in mind. It's going to matter later.
Are you telling me that she has alcohol in the car while she's driving?
She had a cup of alcohol.
Ms. Hawkins, I'm going to find that there's sufficient probable cause to go forward with your case. I am now placing several conditions on your bond. If I find that you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds, ma'am. You're not allowed to drive. I'm taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. This is an affidavit that you're going to promise to me that you're not going to drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, ma'am.
Judge, is that standard for driving?
She has alcohol in the car while she's driving. And so I would presume that it's elementary that you're not to have alcohol in the car while you're driving. It scares me, and I just don't want her driving for now.
After finding probable cause for the DWI charge, Judge Fleischer placed so-called conditions on Ms. Hawkins' bond, ordering her not to consume any alcohol and not to drive at all, despite the fact that the prosecution, in a written motion, had only requested that Ms. Hawkins be required to install an ignition.
This right here is the moment the judge's tone changes. Alcohol in the car while driving isn't just a bad look, it's a massive red flag legally and emotionally. Even before blood results, judges are allowed to think in terms of risk, not guilt. And you can almost hear the judge thinking, if something happens next time, that's on me.
IID as a condition of release. Now, because Ms. Hawkins was a first-time DWI defendant, Article 17.441 did not mandate an IID in her case. However, under Article 17.40 of the Code of Criminal Procedure, judges have broad discretion to impose, quote-unquote, any reasonable condition of bond related to the safety of the community. Now, while judges cannot use bond conditions as a form of punishment before a conviction, as the 14th District Court of Appeals in Houston explained in the 2022 case of Ex parte Bucks, appellate courts review challenges to bond conditions under a so-called abuse of discretion standard. This means that a trial court's decision will...
Let's break this down in plain English. This isn't a punishment, at least legally, it's not supposed to be. Bond conditions are about preventing future harm, not punishing past behavior. The judge isn't saying she's guilty, he's saying, I'm not taking chances. Whether you agree or not, this is textbook judicial discretion in action.
I don't even know what the blood is at this point.
Get it? But she has alcohol allegedly in the car while she's driving. One would presume that that's a humongous no-no, you know? And I want her to appreciate the privilege it is to drive. It's not a right. It's not a right. It's an absolute privilege.
Judge, if I may, what would be the conditions under which she's able to come back and get permission from the court? At what time frame?
I need to know that she understands and appreciates the privilege, you know, be proactive. It's not forever, Aaron, you know, but I want her to understand that it's a privilege, it's not a right, and it's something that people should take very seriously.
With alcohol.
I don't want you to talk here now in front of him. You know, you guys at a later date can come back. I'm always all ears. Like, it's not
For
absolute.
Greg's purposes, since he's going to be the one representing her, what is a later date? I mean, is there something we can do? Because, you know, if it's something that you'd like her to do while on bond to make sure that she's, you know, addressing the issue, I mean.
Be creative, be proactive. I want to know that she appreciates it, and I'm all ears, you know? But it's something that I've seen more and more, you know, where there's alcohol in the car, and I would presume that you would know, especially at this age that, you know.
Well,
Let's break this down in plain English. This isn't a punishment, at least legally, it's not supposed to be. Bond conditions are about preventing future harm, not punishing past behavior. The judge isn't saying she's guilty, he's saying, I'm not taking chances. Whether you agree or not, this is textbook judicial discretion in action.
there's a blood draw pending. According to the dim summary, she had 1.5 drinks. It's certainly possible her alcohol level comes back below the legal limit.
Mr. White argues for driving privileges so that Ms. Hawkins can drive to and from work, and Judge Fleischer maintains the 0 driving condition of bond for the time being. It is important to understand that restrictions on driving as a condition of bond are separate from the status of an individual's driver's license under Texas's administrative license revocation process. Because Ms.
To get those lab results and come back and get this taken care of, she's not driving for 90 days.
I'm not saying that long, Aaron. I just want some kind of proactivity that I know that she appreciates. Come back and, you know,
And just
Hey,
for
you know.
Greg's purposes, so I can convey this to Greg. What's proactivity to the court?
just be creative.
Okay.
Be creative. And, you know, several weeks, come back and we can talk. But it's a privilege. It's not a right. And it's something that we take very seriously. Every single day, someone dies from a DWI in our county. Every single day. And we need to ensure that it's taken seriously, you know? I'm not asking for much. And once we know that there's appreciation, then let's talk again.
On April 8th, 2025, Ms. Hawkins' attorney requested a hearing regarding the conditions of bond, and on April 10th, 2025, Ms. Hawkins made her second appearance in Judge Fleischer's courtroom, accompanied this time by her defense counsel.
Here's the part most people don't realize. Criminal court and driver's license consequences are 2 totally different systems. Even if the judge says, you can drive, the state might still say, nope. That disconnect catches defendants off guard all the time, and it's exactly why DWI cases feel so overwhelming early on.
It's a privilege. It's not a right. You know, every single day on our streets, someone is dying from some kind of alcohol-related collision. That's what we're trying to impart to you here, to take it seriously. It's not a joke, you know? And the last thing I want is for something like that to happen here. You understand? All right. I'll take off the restriction. Okay. What does she have now? I want to make sure that she has an interlock for now, just for a limited time.
Judge, if I can speak to that briefly,
Sure.
just to reassure the court that she fully understands the court position. I had her research and write an essay on alcohol-related accidents and fatalities. We can turn that in and take a decision-making course. Her case is a stop for expired registration, no accident. You got the blood this morning, it's a 1-3. She has no criminal history. So I would ask the court that to use this, the research she's done in the 28 days without driving at all, to understand that she gets it. And if we can not have the interlock, as would have been if she didn't have an open container, that we proceed further.
Here's the full circle moment. Despite a BAC well over the legal limit, the judge loosens restrictions instead of tightening them. Why? Because bond conditions are flexible tools, not moral judgments. Judges can go hard early, then ease up once they're confident the defendant takes the situation seriously. Whether you think that's fair or not, that's the system working exactly as designed.
Life is too short to spend the next month in a 6x9 box.
Mr. Holton informs Judge Fleischer that Ms. Hawkins' blood test returned a BOC of 0.13, exceeding the legal limit of 0.08. Despite this result, Judge Fleischer agrees to remove the no driving condition from Ms. Hawkins' bond, and at Mr. Holton's request, declines to require the installation of an ignition interlock device. Nevertheless, because Ms. Hawkins' BAC was over the legal limit, it is highly likely that her license was subject to administrative suspension, meaning that she could not lawfully drive without either obtaining an occupational driver's license from the district court or successfully contesting the suspension. Now, since the administrative license revocation process is separate from the criminal proceedings, the matter was not addressed during this hearing, so I cannot speak to it definitively. However, as of the date of writing this episode, Ms. Hawkins' DWI charge is still pending. In this episode, we saw Judge Fleischer using the broad discretion over bond conditions that he's granted in his authority as a judge to bar Ms. Hawkins from driving and from consuming alcohol, even though the state had only requested an ignition interlock device. About a month later, Judge Fleischer exercised that same discretion in another hearing to remove the no driving condition, even declining to require an IID. Bond conditions are tools that judges use to address community safety issues while allowing criminal defendants to remain out of custody while their case is being adjudicated. Now, while some viewers may find the initial restrictions unfair given the limited record before the court at arraignment, as the blood alcohol results were not yet back and the contents of the alleged open container had not been tested, others will view those limits as cautious, temporary measures intended to reduce risk while the case is pending, with the expectation that judges will revisit and recalibrate conditions as new information arrives, which is what happened here. Either way, judges have broad authority under Texas law to set reasonable, safety-related bond terms, so the initial driving ban was almost certainly lawful, even if it felt strict or unfair to Ms. Hawkins. Let us know if there's a case or courtroom interaction that you'd like us to cover in the comments below. Thank you for watching, and don't forget to subscribe and share so that we can help foster a more informed society.